morning, everyone. This is Hapco's meeting on October 8th. It's about 9:34 a.m. We have special guests Paul Cohen and Janelle Maricini. We are going to speak on a number of topics. I'll let them explain them what they are because I'm not the expert by any means. But I apologize. Unfortunately, I know as you can probably see, there's a lot of people, so we won't have too much time to be able to actually speak out loud besides Janelle and Paul. So what we will do is we'll take additional questions that you did not email, and if you can post them in the chat, and between Janelle and Paul, we will try our best to field those after they go over everything. And without further ado, I don't know who wants to go first.
We'll take it from here. We're good at this. Thank you so much, Brian. I just wanted to introduce myself quick to everybody. I know you're all used to dealing with Paul, but I am the woman behind the scenes. So as you know, I'm probably the one who's doing all the work. All joking aside, Paul and I have been in business together. I've been around for about 15 years right now, by now. So we've been doing seminars together for about 10 to 12 years. This is our first year doing Zoom seminars, but I will say in the last 8 months, we've probably done about 20 of these together. So we've kind of got it down to a science. So Paul is our, is the expert when it comes to Philadelphia. So he'll be going through everything with you. I'm going to be jumping in from time to time, and I'm also going to monitor the chat, as Brian said. So if you have a question, just pop it in there, and I'm going to kind of interrupt Paul if the question pertains to what he's talking to, rather than save them till the end, because then it'll get confusing. If it's about something that's he's not speaking about, we'll kind of push that off until the end, and we'll go through it then. And then we have a couple of questions that Brian had emailed me that people had emailed in that we'll address as well, if Paul doesn't already answer them when he goes through everything. Okay?
A quick disclaimer. The information that we give you today is only good for today. The law is changing daily. So we don't want you to look at this a week from now. Today is October the 8th, for those of you who are looking at this, the recording of it. So this is only good as of October the 8th. If you're looking at it a week from now, odds are that the law has changed significantly because it keeps changing daily.
It keeps changing by the hour. We did a seminar one time for a set of our clients, and we said on this seminar, expect in Pennsylvania, not Philadelphia alone, the moratorium to be extended to the end of the year. Paul and I were very confident that Wolf was going to do that. And I kid you not, 20 minutes after we hung up the seminar, the call, on the Zoom call, Wolf came out saying he wasn't extending the moratorium. We just started shaking our head. So someone just quickly asked Paul, if I live in Bucks, how do Philly laws compare to Bucks? They are completely different. So when Paul goes through some of the statewide stuff, that'll apply, but this is mainly about Philadelphia today. So the Bucks County, this isn't really going to apply to Bucks County or any of the other surrounding counties. Okay, this is Philadelphia specific today.
Yeah, we're going to touch on it a little bit. I'm going to go through the federal laws. I'm going to go through the state laws, so that obviously applies to the entire state. So that will cover Bucks County as well. And then we're going to get into the specific laws in Philadelphia, which are just a lot.
That'll be the bulk of our time.
The other disclaimer I want to say is that don't shoot the messenger. Okay, we're just passing along the information to you. Although we try to help make the laws, we are not on city council, and we are not the one that are actually passing these laws. We're fighting against a lot of these on behalf of Hapco and others. But like I said, we're just the messenger, so don't shoot us. We're just passing along the information, and the information is generally not good. So take it for what it's worth. Okay, let me get started. So the first thing I want to go over is the federal laws with regard to evictions. So you should all know by now there was originally an eviction moratorium in the CARES Act. It was a federal law that was passed, the CARES Act, and in that it said that there was going to be a moratorium on all evictions through July the 25th. It only covered properties. Okay, I'm going to make that distinction between covered properties and covered people a little later on. So this is a law that only applied to covered properties. Covered property was a property that basically got some type of federal assistance, whether it was direct federal assistance or whether you had assistance through a federally backed loan or a mortgage. Then you were considered a covered property and you couldn't do an eviction through July the 25th. Obviously, July the 25th has passed. If you got a mortgage forbearance on one of your covered properties, then you still can't do the evictions, and that'll go through the end of December. Okay, that's on the federal level. And the problem, and the reason I mention this is that, and I'm talking about it because most of you are thinking, why are we going through this when that has already ended? It's past July the 25th. The law said that after July the 25th, you had to send a notice to quit prior to being able to do an eviction. The notice to quit had to give the tenants 30 days notice to quit. Now, as most of you know, in Pennsylvania, you can waive the notice to quit in the lease agreement. That's a Pennsylvania law. This is now a federal law. The federal law trumps, no pun intended, any state law. Okay? So, when the federal law says that you have to do something, even though the state law may be different, you still have to comply with the federal law. If the state law is more strict, then you still have to comply with that state law and the federal law, but you're always going to have to comply with the federal law. So, under the federal law, even though the moratorium ended on July the 25th, as of July the 26th, you have to send a 30-day notice to quit if you have a covered property, federally assisted property. So that includes properties where you might have a Section 8 tenant, where you have a housing choice voucher. On all those properties, they're considered covered properties. You would have to give that 30 days notice starting on July the 26th. Nobody's really sure when the period ends for having to give the notice. It's not clear in the law, and it hasn't been defined yet. So the safe course of action is to continue to give that notice until we tell you otherwise. Most people are looking at it as give the notice till at least December the 31st. The very conservative approach is to keep giving it until we hear otherwise, that we don't have to give it anymore. If you ask me what's my legal opinion and Janelle's legal opinion, it's that you should only have to give it for 30 days, and after August the 24th, you shouldn't have to give it anymore. But the conservative approach, just to be safe, especially in Philadelphia, give that 30 days notice.
And we're experiencing in the court that the courts in Philadelphia are requiring those notices as of right now. So we need to keep sending those out.
Yes. And it doesn't really hurt you in Philadelphia, because as we will go through the rest of Philadelphia laws, you're not getting into court anytime soon anyway, and there's other things that you have to comply with. So the safe course of action is send out the 30-day notice under the CARES Act if you have a covered property. So that's on the federal level. The other thing that happened on the federal level is the CDC, Centers for Disease Control, issued an order that said that basically you can't take any action to remove or cause the removal of a covered person until after December the 31st of this year. Okay, I'm just going to repeat that real quickly. You can't take any action to remove or cause the removal of a covered person. Now let's look into what that actually means. So the first thing is, it says you can't remove or cause the removal. To me, removing or causing the removal means filing a writ of possession, an alias writ of possession, or actually locking out the tenant. That's removing them from the property. It should not include filing a landlord-tenant complaint. It should not include sending a notice to quit, and it should not include going to court. I can tell you, however, that a lot of the courts throughout the country are ruling that you do, that once the tenant signs a declaration saying that they are a covered person, which I'll get into in a second, then you cannot go into court. And that technically you probably can't even file a notice to quit. We think that's totally wrong. It shouldn't be that way. But unfortunately, different courts are ruling that that's what you have to do. The courts also, and getting back to the law changing every day, so we've been talking to a lot of the courts. And we've get some of them, we've convinced them that that's not the ruling and that you should be able to go into court and it's only the lockout that should be stopped. Some that are still holding that you can't even go into court. Okay, so that's a problem. Right. The other thing is that it says you can't take any action, and that's where they're arguing that because it says any action to remove or cause the removal. Any action they're saying includes the filing of the complaint or doing anything else toward the eviction. Again, I don't think that causing the removal of is the same as causing the eviction of, but different courts are interpreting it differently. And because it's the federal law, we're dealing with this across the entire country. It's not just Pennsylvania or Philadelphia that's dealing with this issue. The entire country is dealing with it. Different states are ruling differently, different localities are ruling differently, and even different judges are ruling differently. So this is just a nightmare. It's a mess. We're trying to sort it out. Until it all gets sorted out and we get a higher court's ruling, we really won't know what the answer to these questions are.
We did get some clarification, though, Paul. Do you want to go through that, or do you want to talk about a covered person first?
Yeah, we did get a little clarification. There was a brief that was filed in response to a court case in the CDC case. And in that brief, the CDC's attorneys actually said that the order doesn't apply to court cases. Will courts listen to that memorandum? Don't know. It's just happened last Friday, so we'll have to wait to see how that all plays out. We're hoping that they will, but we'll see. Like we said before, this stuff changes daily, so we just want to kind of keep you aware of what's going on as of today. Okay. The other thing that you need to know about with the CDC order is that it applies to a covered person. So what is a covered person? So there's 5 criteria to be a covered person. The first thing is the person has to make less than $99,000 a year. They have to have a loss of household income, hours of work, been laid off, or have some kind of extraordinary medical expense. If they get evicted, they have to show that they're either going to be homeless or in some kind of congregate living environment. So those 3 things are really hard for a landlord to prove that the tenant doesn't have that condition. The 99,000, less than 99,000, that's pretty clear. But the other ones are subjective, and it's going to be very difficult for you to argue against it. The 4th and 5th criteria, however, you can argue against. The 4th one is they have to have made a reasonable effort to apply for rental assistance. So what kind of rental assistance have they applied for? What have they done? You can ask those questions. If they haven't done anything, then guess what? They don't fall into the definition of a covered person. The other thing, and this is the most important one, is that they have to have tried to pay you something. Okay? Now, that's a problem for tenants because a lot of these tenants, they're just not paying you a dime. They feel like they just don't have to pay at all. There's an eviction moratorium. They don't have to pay you anything. Well, guess what? Under the CDC order, they have to make a good faith effort to pay you.
It's actually one of the questions, I'm going to jump in quick, that we got emailed is that how are landlords supposed to proceed when they know the tenants haven't paid their rent and they know that they're actually working? And so this is the problem. We agree with you. We should be able to cross-examine them, do something with regard to these declarations, because a lot of our landlords do know if their tenant is working or receiving income. The problem is if the court doesn't even let us get into court to deal with it, then there's nothing we can do. Some courts out in the counties, like I had a case 2 weeks ago out in Bucks County, and the judge let me cross-examine the tenant on this declaration, and he gave me the judgment, and he did find that she was in compliance with the declaration, but he just stayed the order for possession to next year. However, in Philadelphia right now, we're not quite sure how this is going to play out. So, because there's a ton of different judges, so it depends on which judge you get in front of. You're muted. Brian, you can unmute yourself, Paul. Nope. Brian, can you unmute Paul?
Yeah, he did. Sorry.
Okay, there you go.
I accidentally hit the mute button. Sorry about that, Brian. So yes, as Janelle said, when you get into court, that's one of the things you can cross-examine the witnesses on, assuming that you're able to get into court on a case. Some of the counties are allowing us to get into court on these cases and are allowing us to cross-examine the tenants on it. And that's one of the biggest things that you can argue is they haven't paid me a dime. They're paying other bills. You can ask them about that. How much money are you making? Are you getting unemployment compensation? What type of Social Security are you getting? Like, is there any other income that you're getting? Where's that money going? Because you haven't made any effort to pay us anything. You haven't paid $1. So they do have to make some type of effort to make those payments. Okay, so that covers the federal moratoriums that are out there. Okay, on the state level, the eviction moratorium that the governor had put in place has ended. That ended on August the 31st. The governor, we expected, as Janelle had said earlier, after we did a seminar, that he was fully going to go ahead and extend the eviction moratorium. He wanted to do that, but it was his opinion that he didn't have the legal authority to be able to do that. It's kind of suspect in the sense that he already had extended the eviction moratorium, so that if he didn't have the authority to do that, how could he have done it before? But be that as it may, he decided that he didn't have the authority to extend it and didn't, which is a great thing for landlords. He has, however, called upon the legislature to pass a bill extending the eviction moratorium. We don't think that that's going to actually happen. So right now on the state level, there is no eviction moratorium, and you can proceed with evictions on the state level, but keep in mind, you're still prohibited based on the CDC order on the federal level. Okay, now Philadelphia is a whole nother animal. In Philadelphia, there was passed the Emergency Housing Protection Act. Under that act, the evictions were stayed until August the 31st. As of September the 1st, you could start filing evictions if you complied with all the rest of the act, which I'm going to get to in a minute. So in theory, as of September 1st in the city of Philadelphia, you can start filing eviction cases. However, 2 weeks ago, the city introduced an amendment to the Emergency Housing Protection Act. That amendment seeks to extend the eviction moratorium through the end of December 31st. If that bill gets passed, then you will not be able to file an eviction complaint until January, unless you have some really extraordinary circumstance. It's going to apply to not only non-payment of rent, it's going to apply to any other eviction case. You will not be able to file it until January if this bill gets passed. Now, there is a hearing tomorrow in committee on the bill. It's at 1 o'clock. It's going to be a Zoom hearing. We could use as many people as possible to testify at that hearing. So if any of you are willing to do that, that would be extremely helpful. City Council needs to hear from you. They don't need to hear from me, although they hear from me enough. And I can certainly go over, and I will, and I'll be testifying tomorrow as well. And I'll go over all the legal issues with them and the reasons why that bill should not get passed.
So just to jump in there, there's a person who just wrote to us in the emails. This would be a perfect person who says, why is an eviction from January of 2020 being held up? We went through the whole eviction process prior to COVID. We're just waiting for the lockout when the new eviction laws were put in place. I have a tenant that's been living rent-free for 13 months. I have a sole proprietor of some large companies or a conglomerate. I depend on my rental income to live. Why is this fair? You are the exact person that needs to go testify. We understand the frustration. We have a ton of people that we've come across that basically have had tenants that have been living rent-free from January or before. Someone else just texted into the chat. I have the same situation. They need to hear from you, because what happened was all these cases, everything is put on hold right now, and they are not going to allow lockouts this year. They're not happening. We were supposed to already be having lockouts when the moratorium was lifted in the state. They quick passed something through the courts saying they were holding off on the actual lockouts for 2 to 3 weeks. I forget what the date was, just so that these bills can be passed. so that the lockouts never took place. They're not going to take place. If these bills get passed, they're not going to take place until probably, by the time you go through the whole process, you're looking at March or April of next year. So these people are going to be living rent-free for a year and a half. Please go testify if you have this situation. Write to Brian and let him know you're willing to do so. Right? Is that how you want that handled, Brian?
I'm sitting here texting and thinking about how I want to handle it. Let's wait to the end and we'll figure it out.
Okay, because somebody's asking in the
Yeah, well, I'm actually writing a note to myself to respond to that, so I'll let you know.
Okay. And Marie, I do have your chat. Just hold on. I will get to your question in a moment. Okay. Okay.
The thing we ask of all of you, if you could help us and let us know the zip codes that your properties are located in. Totally anonymous. We're not going to use your names. You don't even have to give us your names. We're just looking to be able to give City Council a list of the properties, not the addresses, just the zip codes where Hapco members have properties and how many are in each district. So we can tell the different members that there's X amount of Hapco members that have X amount of properties in your district. So if you could also get that information over to Hapco, and Brian will let you know by the end of this chat, by the end of this seminar, where to go ahead and send that information. We really appreciate that. That'd be very helpful.
We understand everybody's frustration. We're feeling it too.
Yeah, and that's what you guys can do to kind of help this situation. Complaining doesn't help unless you're complaining to the right people. And that's what we really need to see happen. Tenant organizations, tenants are going to be out in force tomorrow. You can be sure they're going to be complaining. So they need to hear from landlords. They need to know that landlords are not, rich people that are making all this money, that you guys are hurting. But this is just an awful thing that they're doing. It's just not allowing you to conduct your business. One of the things I keep asking everyone, especially members of City Council, I say, if you were going to own rental property and you had a choice, would you own it in Philadelphia or outside of Philadelphia? And the answer is obvious with everything that the city is doing. People are just realizing that it just doesn't make sense to be a landlord anymore in the city. And the city needs to hear from you and understand that they keep going down this path, they're not going to have small landlords. Well, they maybe have some of the large landlords, sure. Small landlords, you guys are going to be out of business. This is just terrible. So they need to hear from you. They need to hear your stories. They need to hear what you're actually going through and what these bills are doing to you guys on a personal level. It would be extremely helpful.
Okay, let's get back to what the bills entail before we get too far off. I got to keep them on track, guys.
We talked about the eviction moratorium. The other thing that you need to do is before you can actually file for court, you have to send a 30-day hardship repayment notice. Basically lets the tenant know that they have 30 days within which to reach a hardship repayment agreement with you. The current hardship repayment agreements require that the tenant has the option of paying over 9 months any delinquencies between March the 1st and August the 31st. The problem with the new amendment that's going to be heard tomorrow in committee is that they want to extend that to December the 31st, meaning that any monies that are owed from March the 1st through December 31st can be put into a payment plan and paid over 9 months. That's a problem. The other thing that they want to do is they want to say that if you've already reached the payment agreement with a tenant, so let's say under the original Emergency Housing Protection Act, you sent out the hardship repayment notice and the person came in, they said, I want to reach a payment plan with you. And they reached the payment plan and they said that they're going to pay their back rent over 9 months and they're going to stay current in the ongoing rent. If they stop paying between now and December the 31st, guess what? Under this new bill, they can enter into a new hardship repayment plan and include not only the past plan, but all the additional monies through December the 31st. It's outrageous. I have talked personally last night with City Council's office and explain to them. I mean, that's just, aside from the fact that we don't like this bill at all, that is just ridiculous, and that should not happen. I'm hoping they're going to listen to us and not at least have that piece of it, because that's just crazy. How can a tenant reach an agreement with you and then breach that agreement, and then that agreement basically meant nothing because they can just enter into a new agreement? That's just absurd. And the other thing that they're talking about possibly changing is if the tenant is in default by not paying the ongoing rent, then you can file against them. So this would be in January. And it says that if they've missed 4 of the back payments, which is ridiculous, then you can also file against them.
Just jump in real quick. Marie's saying, you send that notice to vacate before the repayment plan or after? Before. If you have a payment plan, our advice is, this is what Paul's talking about, because he's saying you need to do you need to have the notice anyway. So even if you have a payment plan with them, send the notice anyway, and then do like a formal hardship repayment plan, if that makes sense.
Yeah, so but before you can file for an eviction, you have to send out this notice. So our advice to everyone is that if you have a tenant that's delinquent, immediately, like today, send out the hardship repayment notice, because you want to get that 30 days started as soon as possible. Okay, even though under the law it says you can't take any action in furtherance of seeking eviction, the hardship repayment notice is excluded from that requirement. So you can send a hardship repayment notice, and we're recommending that you do that immediately on someone that hasn't paid.
Any delinquency, even if they're just behind 1 month, get it sent out, because that 1 month will turn into 4 before you can blink.
Yeah, if there's nothing else that you take out of this seminar, take that away, that you need to send that hardship repayment notice.
Okay, Philip says, does that only apply to Philadelphia? Yes, that only applies to Philadelphia. And then someone else asked if there was a template for that notice.
There is. You can go online, and there is a template for it that you can send out. I think it's on the Fair Housing.
Yeah, Fair Housing.
It's also on the city's website. Okay, so make sure you get that notice out right away. When the days goes by, you should then apply for the eviction diversion program, or mediation. I don't know why they call it eviction diversion. They had to put a fancy name on it. It's mediation. You have to basically apply for mediation.
Like, wait, before you get off the notice, Paul, 2 more questions on the notice. How does this apply for cases prior to the moratorium? We didn't think it did, but we are receiving word from our attorney who goes on to court that the judge is requiring one of those notices for anything, if they owe rent, any rent after February of 2020. So if there's any rent that's due starting in March, even if you had a case pending, like this person has a case currently scheduled to be heard on December 24th. I doubt that's even going to get heard. But if it does, in the meantime, send the notice for any rent that was due from February till, if there's any rent due post-rent, ongoing rent, because they're requiring that, or they're only giving us judgments through February. So send those notices now anyway, even if you have a court date. And no, the other questions on here, does an attorney have to send the hardship repayment notice? No, you can do it yourself.
We certainly recommend that you have an attorney do it, because you want to make sure it's done right. This is the kind of thing that if you don't do everything exactly right, when you eventually get into court, which could be months and months and months away, you want to make sure that you're able to proceed with the eviction. If you do anything wrong, that case is going to be thrown out. There's going to be attorneys down there at court. They're going to be looking at every single thing extremely carefully. And they're going to want to make sure that you comply with every single thing you needed to do, because if you haven't, your case will get thrown out, and it's going to be a problem. So if you know what you're doing and you can do it, that's great. If not, definitely recommend you have your attorney do it, so that it's taken care of, it's done right, and you don't have a problem down the road.
Okay, I'm sorry. I just didn't want you to go on to the diversion program. Someone else is asking if Hapco does it if you pay for the comprehensive eviction package. I don't know if that includes that. I'm sorry.
Yeah, there is a program through Hapco that it is being done through the Barrett's law firm. So yes, that is being taken care of. So you can work that out through. You can contact the Hapco office, and they can direct you to make sure that you get it all taken care of properly.
Okay, on to mediation.
After you've gone through, you sent out the hardship repayment notice, you want to apply for mediation. Very important, because if you haven't applied for mediation first, you cannot file for an eviction case. Okay, so it's two things you need to do. Send out the hardship repayment notice, wait the 30 days, and then apply for the mediation program. Go through the mediation program, then you're going to be ready to be able to file your complaint. So come January, when the court's going to start allowing you to file the complaints again, and I know I said that you can still file them now, but that bill is most likely going to get passed. That's going to stop you from being able to do that until January. So you want to make sure all these other things are done first. So come January, when you are able to go ahead and file the complaint, you're ready to go on January the 4th. Because if you're not ready to go and you get delayed, what's going to happen is there's going to be thousands, literally thousands of cases that are going to be filed ahead of you. And we don't know when you're going to get into court. It could be sometime, believe it or not, and as I said, don't shoot the messenger, in 2022. Based on the backlog that they have now, the thousands of cases that are out there, and the continuing backlog that keeps building up, and the fact that once the court allows you to file and they start hearing court cases because of social distancing and safety rules, the court's only hearing half the cases that they were hearing previously. That backlog is just going to continue to grow and grow and grow. The city's hoping that this diversionary program solves a lot of the problem. They're hoping that the rental assistance is going to help. If it does, that'd be awesome. I wouldn't bank on it. I'm guessing that it's not going to help a lot. The rental assistance is good for 6 months. What's going to happen when those 6 months are up and the tenant now has to start paying rent? This is going to be a problem. You're going to see a lot of evictions. Court's not going to be able to handle those evictions. You're not going to get into court anytime soon. So the sooner you get these other things taken care of, the better off you are. So I can't stress it enough to send out, if you have a delinquent tenant, send out that hardship repayment notice immediately. 30 days, and file for the mediation. Get that all out of the way. And by the way, you send out that hardship repayment notice, you may be able to reach a repayment agreement with the tenant and they can start paying. It's great. You might be able to see some reaction from them. You go to mediation, maybe you can reach an agreement through mediation. Maybe mediation helps them to get rental assistance. So you want to, instead of just doing nothing, you want to get that stuff started right away, and that's something you can do to help you with the eviction process. Okay, that's it for the Emergency Housing Protection Act, unless anyone has any questions on that.
There's some other questions in here, but so someone wants to know if there's a Zoom link for the hearing tomorrow. Is it posted on their website or something?
Yeah, I have an email that they're going to send us messages about that, and I'll send it to them. So.
Okay, great. And then people have some questions, and there were some variations on these questions, and there was a few in the email that came across as well, the emails that came across, excuse me, about not just non-payment of rent cases, Paul. There's some with regard to some breach cases. What do people do in the situation if someone's not allowing them in for repairs? Was one of them, someone else had a leak? What do they do about that, and they didn't report it? What do you do in the situations if there's a breach case?
Okay, so in Philadelphia, unless it's really bad, you're not going to be able to get into court. The counties, it's different because the CDC moratorium only applies to non-payment of rent. But in Philadelphia, it applies to all cases. So as of today, you can still file. So I just want to make sure it's clear that that new bill hasn't gotten passed, and hopefully you all testify tomorrow and we can stop it. But assuming that it does pass, which I'm guessing it will at the end of the day, might get a little modified, but assuming that bill passes, then you will not be able to file even for breaches of conditions of a lease agreement, even for termination of the term. You won't be able to file until January. All right, moving on.
Moving on.
All right. The last topic I wanted to talk to you about is lead paint.
Oh, yeah, there's some questions about that, too.
Okay, good. Very important. So the new lead paint ordinance went into effect as of October the 1st. So starting October the 1st, you need to comply with the new lead paint law, which basically says that every single property needs to be inspected for lead paint, unless it was built after March of 1978, or it's lead-free. So if you got your property certified as lead-free, you're good. Lead-free means there's no lead at all on the property. Somebody's come out, they've inspected it, they've shown that it's lead-free, you're good. There's no lead there. If you have lead in the walls and you've painted over it, it's been encapsulated, then that's not lead-free. Then hopefully it's lead-safe. Okay? So if you've lead in your property, it's built before 1978, you need to have a test done and certified that your property is lead-safe. Okay? Prior law said that you only had to do it if you had a child 6 or under living in the property. As of October the 1st, that is no longer the law. The law is being rolled out in 6-month increments. And it's being done based on zip codes. So if you go to the city's website, you will see which zip codes are have to come into compliance as of October the 1st of this year. Check out your properties, see which zip codes you're in, and determine when you need to come into compliance with any particular property. So there's a lot of zip codes that are coming online on October the 1st of this year. A lot more are coming online on April the 1st of 2021, then October the 1st of 2021, and finally all properties need to be in compliance by April the 1st of 2022. Okay. When do you need to be in compliance as of? The old law said that you only needed to be in compliance as of the date or as of the inception of a lease agreement. So when you rented to a new tenant, you had to make sure that your property was lead-free if you had a child 6 or under living in the property. Under the new law, it applies to every property, as I said, on the rolling zip codes, as far as the date goes. And it applies not only at the inception of the lease agreement, but it also applies on the renewals of the lease agreement, and it also applies as of the renewal date of your license. So it's the earlier of those 3 dates, the earlier of a new tenant moving in, a lease being renewed, or your license being renewed. So at most, you're going to have a period of 1 year before you're going to have to do it, depending on when your license is being renewed. If you do not have that certification, you will not be able to get a license, and you will not be able to collect rent legally. That's a problem. So you want to make sure you get those lead paint certifications done as soon as possible.
And Victor just wrote in, Hapco has all the info of which of the zip codes on their website. I'm guessing for the lead paint. I don't know if he means for lead paint or just what zip code covered.
It's for the rolling zip codes for when they come online. It's on Hapco's website. Just a real quick plug, you guys should be checking Hapco's website very often. There's a lot of information that's up there. We try and keep it up to date. Very good resource for landlords. So if you're wondering what's going on with regard to landlords, it's a great place to start. And I would check it often. So
okay, there are a million questions with regard to lead paint, so let's kind of get through these a little bit, okay? Some of them are easier than others. So the first one is, I had my property inspected last year. Does my certification expire?
Great question. So as of last year, the certifications were good for 2 years. Starting in February of this year, the certifications are good for 4 years. So if you got a certification as of February 1st or later of this year, that certification is good for 4 years. Mark your calendar, 4 years from now. Keep in mind you need to renew that certification. Okay. If you had it before February, then that certification was good for 2 years. So calendar it, 2 years from that period, you should get a new certification done. Okay, it doesn't have to be done on the exact date of the 2 years. Keep in mind, as I said before, has to be done the earlier of when you rent it to a new tenant, lease renewal, or license renewal. So after the 2 years are up, whichever of those things come first, that's the date that you have to have the new certification done by.
Okay.
Once you've done the new certification, it will be good for 4 years.
I think that answers Brendan's questions too, because he was asking, does it have to be done by 10/1 or by the renewal date? So that'll answer that question too. Who inspects the property? Somebody's asking.
So the inspection can be done by has to be somebody that's been certified, that's gone through the testing. You can have your own people go through the thing and get certified to do it, but it's not the city. It's a private company that you can hire to go ahead and do the testing.
Okay, real easy question. If you only have adults living in your property, do you still need the certification? Yes. That's the new change in the law. Okay.
It's like every property, not just properties where there's a child 6 or under. It's every single property, and it also applies to HUD properties. That was an exclusion before, no longer applies to HUD properties as well.
If you do a lead dust swipe test and it fails, what should you do after that? So you need to hire a company.
So you need to do the remediation work. So at that point, you need to make sure that the lead is encapsulated, properly taken care of. You may want to have the property certified as lead free, so you may want to remove all the lead. There's a lot of options with which ways to go. But the bottom line of it is you absolutely have to take care of that problem immediately.
And then someone asked what are the certifying companies called, and then somebody else actually answered it and gave them a name of one of the companies. So there you go. And I think that's it on lead questions. There was one online, but they just asked if you were going to talk about lead, I think. Let me just make sure. Yeah, I think you're talking about the fines with regard to lead, the $2,000 a day.
Yeah, the biggest problem you have is not just the fines, because obviously that can get expensive, but the bigger problem you have is that the tenant doesn't have to pay the rent. And not only don't they have to pay the ongoing rent, they're entitled to the money back that they've already paid you if you don't have the proper lead paint certification. It's a huge problem for landlords. It's something you absolutely positively want to make sure you get taken care of, because if not, it gets very expensive. In addition to the fines, you're not going to collect any rent, and you're going to owe all that rent back. That's a problem.
And there's an additional problem here that Marie just actually wrote me privately on. She said one of her properties, the tenants don't want people in the apartment right now because of COVID to take care of the lead problem.
Yeah, that's a huge problem. And it's one of the things that we've been arguing with City Council, that they should extend the start date, or they should have extended the start date. And we're still hoping that there's regulations as to L&I extending the start date because of these problems. If the tenant doesn't allow you into the property, document it, and have them sign something that says they're not allowing you into the property, if you can get them to do that, and then you can use that instead of the certification. That's valid. If they're not allowing you into the property, that's an absolute defense, and it's absolutely okay for you not to have the certification. Now, having said that, you now have to prove it, and you got to get L&I to agree to that. That's a little bit of a problem. So what you really want to do is get that certification, get the test done, try and convince the tenant it's in their best interest to have it done. You want to make sure that the property is safe, et cetera, but you are in much better shape if you're able to do the test.
That was it from what I'm seeing.
Okay, tried to keep this under an hour. I think we did pretty good. Nobody has any other questions. Thank you all for listening. I'm going to try and do these periodically to keep you all up to date. And as I said before, don't shoot the messenger. It's just passing along this information. And after today, it's no longer valid.
Someone did ask where are they going to be able to find this recording of this today? Brian, are you posting this on Hapco's website or something?
This I'll give a couple updates after once you guys are done.
Okay.
Are you guys done, I guess?
Yep, tell you.
So I'm typing in the chat, and I'll say it now. There's an email that if you guys have any questions hopefully you spent time actually listening. I'm not trying to be smart, but we try to be hopefully the questions are more complicated, if that makes any sense. But what we'll do is we're going to post this recording on the website. I can't promise it's going to be today or tomorrow, but it'll be on there soon. If you have questions, I'm typing in the chat an email, which is denise@hapcophiladelphia.com. Obviously, my name is Brian, but I'll probably be the person responding back, but my name is not Denise. But that'll be the website or the email address. What I'm going to do is whoever emails me about the hearing tomorrow, I'll send you the information. It's not complicated, but you need to be diligent about getting on that as soon as possible. If you have other questions about some of the topics that we discussed today, again, the recording will be posted on the website. And hopefully, good luck with everybody. Hopefully, we helped you at least a little bit better today.
Have a great day, everyone.
Thanks, guys.
Thank you.